Good afternoon, everyone. My name's Adam Dooley. I'm your co-host here for this live stream on legal matters with Philippe Rocher of TLR Law. Hi, Philippe.
Hi, Adam. How are you?
I'm doing really well. So our goal with this live stream is to discuss some legal challenges that regular people typically face in their personal or professional lives. And our job is going to be to tease out some of the best strategies for you to avoid major and maybe costly mistakes. Today we're going to talk about the family cottage. Is that something that you frequently see problems arise when you're dealing with family cottages?
Yeah, so it is something that happens quite often when we're talking specifically here about when in an estate situation. So the topic we're going to talk about today really has to do with estates and passing assets on to a next generation. So it is something that comes to mind. It's certainly something that we talk to our clients about when they're preparing their wills and they're preparing their estate succession plan. And if you don't do it right, you can end up in tricky situations. You're not there anymore, of course, because you've passed away, but your children could be stuck there. So if you're an executor, on the other hand, you could be saddled with some of this stuff. So yeah, it can get pretty tricky.
So family cottages, there's always so much emotion that comes into the discussion of family cottages. Well, maybe not always, but frequently, where multiple siblings will have really strong connections, emotional connections to that cottage, and obviously families are just rife with emotional connections just because by their very nature. So I imagine it leads to some difficult conversations or maybe some challenging ones with your clients.
Yeah, no, absolutely. The family cottage, as you pointed out, so there's two aspects of it. There's the emotional aspect to it, which is charged, and I think everybody can understand that. As you said, cottages are all about family memories and growing up. And if parents have had a cottage for a long time and you were a child and you grew up at the cottage and then you had children of your own and start bringing your children to the cottage, you'll have this really powerful emotional attachment. And cottage is fun, right? Everybody goes to the cottage, so you have this history of really emotionally charged feelings about it. And that's not a legal issue, of course. That's just the emotional attachment to it. But it can lead to problems there if after a parent's passing or both parents passing and it's time to pass down the cottage, maybe some of the kids have moved away, maybe some of the kids have different ideas of what to do with the cottage, and it can create a lot of tension. And that's one problem to guard against, and that's avoidable if the parents, before they pass away, sit down with the children and talk about, make a plan and talk about their plan. Unfortunately, that doesn't always happen.
Right.
People don't always like talking about their death and their passing, or they know that the kids already do have different ideas and they just don't want to create more conflict, so they don't address it. So there's that aspect of it, which is the emotional family ties aspect to it, and again, it's not necessarily a legal issue other than rights under the will and those types of things, which are very specific. The other aspect of it, which gets really tricky, is of course the legal side. And the legal side, you have a number of rules and laws that kind of converge and can create conflict in that situation. So it's important to be aware of the kind of problems that arise on passing, especially the problems that arise in light of the Income Tax Act. So CRA always likes getting their piece of the pie, and they don't really care about what that does to the family. So.
No, yeah. They don't sit around the Christmas dinner table arguing later. They're just happy with the tax fund coming in.
Yeah.
Well, why don't we dive right into a situation that we've developed here, because I think it's a really good example of what we think might be a really fair looking will. So let's say I'm the executor for my dad who's just passed. So we can bring up the slide here that we're going to be showing. So let's say I'm the executor, dad's just passed away, mom is predeceased, and of course there is family history before that. But I have a sister and a brother who both live in Calgary. So there's 3 siblings all together. Dad wanted me to have the cottage because I live close and I use it all the time. Right. And the other 2 were supposed to get the RRSPs and other investments. So Dad has given my fictional brother and sister or made them beneficiaries for the RRSPs, and he's willed the cottage to me.
Right.
And so the will says the condo is meant to be split 3 ways. Okay.
Right.
So let's assume, just for really a simple example, the RRSPs are worth twice as much as the condo or as the cottage, and so that way, let's say it's the cottage is worth $500,000 and the RRSPs are worth $1 million. The RRSPs are split evenly. I get the cottage. It looks like everyone gets the exact same amount.
Right.
This is a perfect situation, right? This is great. What could go wrong?
Nothing can go wrong in this situation. Yeah, yeah. So on its surface, that does look entirely fair, right? Everybody gets $500,000 worth of value, and then the condominium is split 3 ways. So the kids each get exactly 1/3 of the assets that Dad intended, and that's what Dad's intention was, right? He didn't want to prefer one kid over the other. He knew that Adam, you wanted the cottage. The other kids were okay with the fact that you got the cottage. They were still welcome there. You know, I'm embellishing on the scenario a little bit here for the purpose of our conversation, but so on the surface it looks fine. And from time to time we do see this. So this is a big problem. If somebody comes to me to prepare a will and they give me this scenario, I immediately advise against it, and I can't imagine there would be any lawyer in the city that would advise to go this way, because
why is that?
Well, because there are a number of tax consequences here that are probably not intended, that will completely skew the percentages. So Adam, at the end of the day, in this situation, the way this is done up, you would end up with significantly less than your brother and sister.
Really?
Let me explain how. So first of all, the first problem we have is the RRSP designation, right? So Dad, in this case, did not let the money from the RRSP flow into the will. What he did is he created a beneficiary. So in accordance with the rules that apply to this, any beneficiary designation under a life insurance, under RRSPs, bypass the will completely. So it doesn't fall in, so if you want a visual, it doesn't fall into the bucket of assets that are distributed by the will. It bypasses that. At law, it's considered an inter vivos gift, which means on the last breath that you have, you give all of that to the beneficiaries. So it doesn't go into the will. It doesn't pass go. Don't collect $200, and it goes directly to in this case, your 2 siblings. So they each got $500,000. Wow, now the siblings are super happy about that because they get $500,000 clear. They don't have to pay tax on that. But there is a taxable event because there's this rule under the Income Tax Act that says that when somebody dies, there's a deemed disposition. So deemed disposition is fancy legal, it's not that fancy, but it's a legal term or an accounting term that we use quite a bit, which simply means that when you die, in the eyes of Revenue Canada, whether you've disposed of your assets or not, in the eyes of Revenue Canada, you just sold all of your assets at fair market value. Not at a gifted value, at a reduced gifted value, at fair market value. RRSPs, we know that when you cash in your RRSPs, there's a tax event, right? If you have RRSPs or RIFs, when you put the money into the RRSP and the RIF, you declare that to Revenue Canada, and you take that out of your income, and you don't pay the tax on that. And the idea is that when you retire, you start taking the money out at that point, and you start paying taxes on it during that RIF period when you're retiring. So on your date of death, in this case, your mom predeceased your dad, so your dad was the surviving spouse. So on the date of his death, his $1 million in RRSPs would have been deemed to have been taken out of RRSPs, would have been deemed to have been cashed in. So your dad on the date of death will have to file an income tax return. He would likely have made income during that year. So if he was on CPP even, or OAS, even if you were just looking at some basic stuff, plus maybe a company pension. So maybe he made $30,000 by the time he passed away. On top of that, you have to add the $1 million cashed in from RSPs. So that year he made $1,030,000.
Okay.
The income tax on that is going to be significant. It's
Yeah.
going to be probably $400,000, maybe $500,000.
And as the executor, it's my responsibility to file that last tax return.
Right. So exactly, it's your responsibility, but the tax is payable not from the money that flows to the kids.
Right, because that one's now already, because that bypassed the will.
That bypassed the will. So the tax is payable by the estate. So the estate, the only assets in this case that have fallen into that estate bucket are the cottage and the condo.
Right.
So you've got a cottage worth $500,000 and you've got a condo worth, I don't know, let's just say $300,000. So now you have $800,000 worth of assets in the bucket for estate. The estate has to pay now the taxes for the RSPs, which is that $400,000, $500,000.
Right.
You liquidate the condo, there's not enough money there. So you have to liquidate the cottage. So Adam, you probably wouldn't end up with the cottage unless you come up with your own money outside of this to pay for the difference so that you can pay the tax bill. But if there's not enough cash there, you'll have to liquidate the cottage and to get enough money to pay for that income tax. Now,
so what's the better solution here? I mean, I guess maybe let's deal with it. Let's say this is actually happening. What would you advise? What would you advise on this situation?
Before we get to what I would advise, I want to continue with this scary situation because it gets worse.
Okay, it gets worse. Okay.
Okay. So now you're the executor and you see your cottage disappearing before your eyes because you have this huge tax bill that you have to pay out of the estate, and there's not enough money there to pay for it unless you liquidate both, sell both properties. Well, most cottage owners know, are aware, or have heard of the capital gains. Whenever you sell a property that is not your primary residence, there's a capital gains there. If this cottage was bought 30 years ago for $50,000 and it's worth $500,000 now, you just made a $450,000 capital gains. So that $450,000 capital gains gets added to the income that your dad already has to declare that year of $1 million. So capital gains is taxed at 50% of the gain. So you take the $500,000 fair market value less the $50,000 paid for, so you have a $450,000 gain. Half of that is what, $225,000? So that gets added to your dad's income. So now your $400,000 tax bill goes up even further, another probably close to $100,000. So now you might be looking at $500,000 and $600,000 in taxes that have to be paid out of what's left over.
So Dad thought he was treating everyone fairly, and in fact, me as the executor, I'm getting absolutely hosed. I probably end up having to sell the cottage that I wanted to keep.
Right. So it's not you as executor that gets hosed, because you have two roles here. You're the executor, which is responsible for managing the estate. But you're also a beneficiary, and it's you as a beneficiary that gets hosed in this kind of situation. And to add insult to injury, you as executor are the one hosing you as beneficiary.
just to make it better. So what would you advise? I guess you could always talk to your siblings, or in this case, I could talk to my siblings in Calgary and say, hey guys, here's the tax consequences. Do you mind cutting me a check from the cash that you got and help me pay for some of these taxes? That would be one option, right? And that doesn't need to involve the estate at all. That's just a discussion between me and my siblings.
Right. So there's maybe two ways to answer your question. The first way to answer your question is avoid this problem to begin with. Now, you as executor, you can't avoid that because it's not your decision, right? It's your dad who would have to plan properly. So all of these things can be avoided by consulting with a lawyer beforehand and an accountant and getting your will done properly, so that your kids don't end up in this situation. But that's not always a possibility, right? Sometimes kids encourage their parents. I see it happen quite regularly. They encourage their parents to create a will, and they do their will, and they come to see me and they complain that their parents aren't dealing with it. And there's a number of reasons for that. Facing your own mortality, we've talked about that earlier. It can be challenging. So If possible, this should be addressed at the time of making the will. A much better way of doing it in this case is to make a will where you put everything into the estate. So dad in this case would designate the estate as the beneficiary, and then everything falls into the estate. And then it's from the estate that you, Adam, would distribute everything. And then he would just say, and I'm giving everything 3 ways to the kids and let them sort it out. So in this case, you would just buy out your siblings. They would get more of the cash, and you would get the cottage.
That's assuming that me and my siblings are getting along, though, right? Because or it assumes that only one person wants the cottage.
Right. And the siblings in Calgary may not want the cottage. It may not make sense to them to have the cottage. So in that situation, it's always better to do it that way. Your dad could also put that he would like you to have the cottage and have the option. There's things we can do to a will that if kids are not getting along, that we can incorporate that in the will, that Adam has the first right, and there's a process by which you get the property evaluated, and that you put in an offer and you get the proper financing. You can use your portion of the estate to finance it and that kind of thing. So there's ways of dealing with that even when the siblings are not getting along. Of inserting an option to buy essentially for Adam in this case. But a much better way of dealing with this scenario is to just have the entire estate go to the 3 kids equally. That way the estate pays the bills off the top, which include the income tax. So that means the $100,000 in RSPs would be there, or the $1 million in RSPs would be in there, plus the condominium. You could sell it. You're likely to sell the condominium, the primary residence. There's no taxes on that because that's an exception under the Income Tax Act. So you would have cash there to pay off the estate. What's left over would be the cottage worth $500,000 plus whatever cash is left over, and then you would just divide that value 3 ways, and then you would compensate your siblings for the cottage.
Sure.
So that's avoiding the problem.
Right, which is always better, right?
Right, which is always better and cheaper.
Yeah.
In this scenario, it's not your fault. Your dad just did what he did, and you're stuck with and it can't be changed at this point. So in this situation, if the siblings are collegial and all get along and knew what dad wanted, and that these now tax rules have completely flipped that on its head. Once they receive the cash, it's theirs. They can do what they want with it. So as long as all the beneficiaries agree, they can give you some money back, and there's no tax event at that point because taxes have already been paid. So you can do a redistribution between beneficiaries. You can do that on a handshake, or you can do that with a contract. I've done that before, where there were the will was ambiguous, and there were some charities involved. So we negotiated a settlement with everybody, and then we just signed a contract saying this is what everybody's agreed to. Charities got a portion, and all the children and grandchildren got a portion, and everybody was happy with that. So you can do it in your case. If it's the 3 siblings that get along, they can do what they want. It doesn't need to be formalized by a contract. If there are outside charities, that type of thing that are involved, then you'd probably want some kind of agreement that shows what everybody agreed to. So there's nobody that comes around later on and says, hey, wait a minute, we're challenging the will now. Right. So that type of situation. It gets a lot trickier, though, if the siblings don't get along, right? If they don't get along and you have 2 siblings that are receiving $500,000 each, they are unlikely to want to give some of that money back to the sibling that they don't like.
Right, unfortunately, and those things do happen, right? I'm sure you see them all the time in your practice.
Yeah, money does funny things to people.
Yeah.
It
so
has
it's really, well, you're right, and it does, and it can really hurt family relationships for a long time after this kind of event. And I guess the bottom line is it's really much better all the time to have these things sorted out well in advance. As you pointed out, do you have a recommendation for people if maybe they've done their will many years ago? How frequently should you be revisiting those things just to take a look? Sit down with your lawyer to make sure that your will is really reflecting what you want it to reflect.
Right. That's a good question. There is no rule of thumb every 5 years. I mean, I've read stuff on the internet that says every 5 years you should revisit. You should revisit the will whenever there's a significant change. So if you're a young family and you have a will, you usually appoint guardians, you usually appoint other people as executors, and so on and so forth. So in that case, when your kids become adults, you may want to revise your will at that point, because you no longer need to appoint other people as your executors. And typically those are people that tend to be your age. When you have a young family, it would be siblings or even parents. As you get older, it's not a good idea to have people the same age as you as executors. You probably want a younger generation to take care of that. So typically people will appoint their kids. So when their kids reach the age of majority and are mature enough, there's a caveat there, because I remember when I was 18, nobody should have appointed me as an executor back then. So provided your kids are mature enough and they reach the age of majority, you may want to revise your will at that point. Right. The other time you may want to revise your will is if your spouse passes away. It doesn't necessarily mean we have to make changes, but it's a good idea to take another look at it. Or if you get married, for sure, because a marriage revokes the will. So if you get married with somebody, whatever will you have in place disappears. So for sure then. And if you get divorced, of course, you don't. And while a marriage revokes a will, divorce does not revoke a will. So if you don't update your will, all of your stuff might go to your divorced spouse, which if any of you have been divorced, you will understand how awkward that might make you feel.
That would open up a whole other can of worms for a family to deal with.
So whenever there's a big change, or if you're having trouble with one of your kids, or you benefit one child over the others during the lifetime because of life situations, you may want to change your will at that point to reflect the fact that one of your kids received more or less than the others, so that they receive more or less on your passing. So those kind of situations.
Makes sense. Well, thank you very much for taking us just at a high level through some of these common estate problems with the family cottage. I encourage everyone to stay tuned. We're going to be doing these live streams on a regular basis in the future, going through a whole bunch of different common scenarios that regular folks like you and I have to deal with in our personal and professional lives. You can subscribe to Philippe's newsletter, which is packed with great useful tips all the time, at tlrlaw.ca. That's tlrlaw.ca. Thanks again, Philippe, and we'll see you next time.
Great, Adam. Thanks.